Greetings, ladies and gentlemen. Coming to you today from the friendly confines of my own home. As a matter of fact, the living room of my own home. I have the TV in front of me, so I'll try not to look at it. Um, Today I want to finish off, kind of, I guess this would be lecture one, part two, or 1B. I know I started off with the intro. Today we're going to talk about legal writing. That's one thing that's important you're going to have to do during this class because you have two legal writing assignments. I call it legal writing, but it's actually a persuasive essay writing, but it's just a specific type of specific essay writing that we use in legal reasoning. So, of course, my job as an attorney, um, I get facts in front of me every day. Clients come in, things happen, and people come in asking me questions, and I need facts. Well, for one, I need law. I need a rule of law. And on top of that, I need facts. In legal writing, those are the main two things you're going to be using: facts and primarily rules of law and facts. You'll probably get facts first in real life, and you'll have to figure out what rule of law would apply. What is my client charged with? What does the prosecution have to prove? So we're going to merge those two things or use those two things to come to answer questions. So the question may be, is this person guilty or not of murder or not? So that means that's going to require that we know what the rule of law is for murder. Then we're going to have to apply the rule of law to the facts that we're giving to answer that question. So, first degree murder has different elements. So we're going to have to, figure out what are the elements of first degree murder. And then we're going to have to look at the facts and see if each one of those elements are met. Because in the court of law and criminal justice, um, things have to be proved that every element of the crime have to be proved. I mean, it has to be proven beyond a reasonable doubt. So I'm going to teach you how to answer legal questions. So of course, this is criminal procedure, not criminal law. So you're not going to be answering a murder question because murder is criminal law, and we'll talk about what the difference is between um, criminal procedure versus substantive criminal law. Where substantive criminal law teaches us what's legal and what isn't illegal, as opposed to criminal procedure teaching us what the essentially uh, criminal procedure governs interactions between law enforcement and us as people. So what are the rules that apply to them when it comes to investigating? What are your rights? What can they do and what can they not do? So that's criminal procedure, and we'll talk more about that, but that's not for today. So you'll be answering questions. You'll might get a fact hypothetical about someone being stopped, but they're driving. They're being pulled over by police, and yada yada yada. And next thing you know, drugs have been confiscated, and the person is arrested. And of course, as always in the criminal justice system, when someone feels like their rights are violated, one of the remedies they have is to file a motion to suppress the evidence based upon some violation of the law. So I'm going to teach you the laws that govern police stops and police encounters, namely the Fourth Amendment. So the Fourth Amendment is about search and seizure, and what officers can do when they pull you over. So I'll give you a fact hypothetical. So by the time we get through the body of law and through the chapters, you'll have law. You get a fact hypothetical, and at the end of the fact hypothetical will ask you a question. And where my class design, I give you, I need a 2-page answer. Of course, this is not law school, so I'm not giving you 30 minutes to do it, which is essentially what we had per essay. But you'll have a little bit, well, a lot of bit more time. Like something you take home with you and bring back. But we won't get into that. But I want to teach you guys how to answer legal questions. It's a very um, it is persuasive essay writing, because when you're writing legal essays, essentially what you're doing is you're stating your contention or stating what the issue is. You're applying the law, and you're trying to convince me that you're right. So you're trying to say this person, this. Let me say what context we were talking about. We were in the motion to suppress. This motion to suppress should be denied, and why? It should be denied because based upon the officer's actions and applying the Fourth Amendment standard of search having to be based upon probable cause, search having to be a reasonable search being based upon probable cause. This officer was in the right. This officer did not violate the driver's Fourth Amendment rights. Therefore, the driver's motion to suppress the evidence that was confiscated as a part of his stop and the search is denied, and therefore the state can move forward. So there's a lot of procedural things I just said in there as well that we get to. But that's what you're doing is persuasive essay writing. So of course, in a law, we can't just say you should grant this motion to suppress because I said so. It doesn't work like that. You actually have to give your reasoning. You have to state the body of law that applies, and that's what we do in law, specifically the on the judiciary side. We don't make laws; we interpret laws. That's what attorneys do. Laws are applied in court every day, and a lot of times we're arguing based upon how we believe the law should be applied. And that's interpretation. What does the law mean? Because you'll be surprised, a lot of laws aren't written well. You always have a law or some type of law that applies to a situation, but sometimes it's ambiguous. So we kind of get rid of a lot of the ambiguity because it goes to the court system, and the court recognizes the ambiguity, so the court fills in those gaps. So this is what it means, and we're going to interpret it to mean this or that. So that's essentially our job in the court system. But back to the point. I want to teach you guys legal writing or persuasive essay writing. Three main types of persuasive essay writings. There are three main ones that I know. I'm going to teach you those, but only two of them actually apply in legal writing. So the first is the most basic, and if you're from North Carolina, went to school in North Carolina, I'm a little bit older. We should take a state writing exam where we were given a prompt and we had to answer in a persuasive format. So even as kids in fourth grade, we had to be able to. They were teaching us how to express ourselves and back it up with evidence. So what we were taught was the 5-paragraph theme. So you're asked a question. You have a yes or no answer to the question, but it's not just about yes or no. It's about explaining yes or no, giving reasons. So the 5-paragraph theme is just that, and of course, it doesn't have to just be 5 paragraphs, or it can be less or more. But there are two main paragraphs you have to have. You have to have the contention or the thesis paragraph, where you're essentially stating what your point of view is or what you're trying to say, and of course, you have to have the bookend, the one at the back, and that is the conclusory paragraph. So you can have any number of paragraphs in the middle, but normally the way they taught us was, we had to have that contention or thesis paragraph, and the bookend was the conclusory paragraph, and we were allowed. They made us have 3 paragraphs in the middle. So 5-paragraph theme writing essentially says, I'm trying to think of what am I watching on TV. I'm watching the History Channel right now. You see, I keep looking up. My opinion may be the History Channel is the best channel on cable TV. That's my contention. What I had to do is say why. So to make it a 5-paragraph paper, I had to give 3 reasons why. So I'll give you 3 reasons now. We'll just please indulge and follow along. First reason, it is very informative. They teach you things about history. So that's the first reason, very informative. 2 is very entertaining. I'll say that it's very entertaining, meaning that it's not boring, right? And my third reason is that what they're teaching is pretty factual. It's pretty point on. If you were to fact check it, most of the stuff they talk about on the History Channel is true. So 3 things we're talking about: informative, what I say, informative, not fun. Informative, entertaining, and truthful. So in my 5-paragraph thing, the first thing I do, I open up with a thesis, with my thesis statement. My thesis statement is the History Channel is the best channel on cable TV. It is the best channel. That's one sentence right there. That's what you open up with. So in 5-paragraph theme writing, within the first 1 or 2 sentences, I would say the first sentence, we need to know what you're trying to say. What is your contention? What are you trying to tell us? So you say that. Of course, then you have maybe three or four more filler sentences. Well, actually, going to be more than three or four filler sentences. But the second sentence should be the first reason why. So the History Channel is the best channel on cable TV. The first reason why the History Channel well, or you should say there are three reasons why the History Channel is the best channel on cable TV. The first reason is the History Channel is very informative. They give you a lot of information and things that you can use, even though they may be trivial. The thing is information is good to know. The second reason why the History Channel is the best channel on TV is because it is very entertaining. It gets your attention. They have different types of shows. The third reason that the History Channel is the best channel on cable TV is because they are truthful. What they're telling is the truth, and it has been fact checked and has been found to be true. So it's accurate. So um, you wouldn't say in conclusion then, but you can end with another sentence saying the History Channel. For those three reasons, the History Channel is the best channel on cable TV. So you see how I probably gave about 5 or 6 plus sentences. Now, a good paragraph usually is built off at least 3 sentences. So I just gave about 5, 6. It probably might have been a 7th sentence in there somewhere. So that's one paragraph. So if you can imagine, if I had to type that out in 2 pages, I've just given 7 sentences, so that's a pretty deep. That's a decent sized paragraph. That matches might be a pretty big paragraph. So that's a nice paragraph. And that's my opening paragraph. So I'm already 1/5 of the way through my writing. So got one paragraph. So the second paragraph that's where we go deeper and delve deeper into the first reason why the History Channel is the best channel on cable TV. So we say we open up by saying the first reason why the History Channel is the best channel on cable TV is that it is very informative. So of course, now I'm just talking off the head right now. Um, but before we even put pen to paper and start writing, the first thing we would do is we would plan our writing, and this is what I will want you guys to do. Before you start writing, first you need to think: what is your contention? What are you trying to say in this legal hypothetical I give you? Whatever. Should the motion to suppress be allowed or not? Whatever you choose. So and whatever answer you choose, as a matter of fact, you want to read the prompt a few times as well. So you want to read at least 3 times. You want to read the first time just to read it, figure out what's going on, read again to kind of really figure out what's going on again, and maybe figure out what the issues are and what law applies. And then the third thing you want to read a third time to kind of see what facts are important, and what facts are going to help you answer the question. So legal hypotheticals, just like real life hypothetical, well, not hypotheticals. When people come to my office and they have issues, they're always thick facts. It's not even what's on the warrant. They're always facts, a lot of facts. Where were you coming from? Okay, what were you doing? What time of day was it? All that stuff matters, right? Um, so legal hypotheticals, when you're given a writing prompt, they're going to be the same way. Where they're going to be facts in there. As a matter of fact, these things are written by law professors, written by most of your hypotheticals, all of your hypotheticals, your essay questions are written by me. So I'm writing them, and I know what answer I want you guys to give me because I know I made it up. And I have to give you clues and give you facts so that you can apply those facts. So I'm looking to see whether or not you noticed what was important. So you have to figure out what the issue is, and we'll get the issue in a minute. But you figure out what answer, you read a couple times, and then you have to get to planning. So before you even put pen to paper, or you're not physically writing. These days we type everything, print it out, and turn it in. So before you put finger to keyboard, you need to first, I would say, put pen to paper and write and plan your writing. We call in the 5 paragraph theme teachings, we called it webbing, where you essentially have your contention in the middle and you draw lines to other circles. And of course, in this situation, you have 3 circles stemming from the main circle in the middle, which is your contention. So you have circles away from it. That you have lines from that circle out to those other 3 points, and those are your 3 points. Then from those 3 points you want to make, and of course now, okay, I know this is I mix you up, but now we're back to the History Channel. So what was our first reason? Our first reason was that it was informative. So in one of those circles, we put the History Channel. One of the reasons being that it's informative. In another circle, we put it is entertaining, and in the last circle, we put that it is truthful or it's accurate. So we do that. So now we choose each circle, and we go one circle at a time. So we're going to start with informative. So we start with an informative. Now we have to give reasons why it's informative. So first reason why it's informative is they have the top scholars that contribute to giving the information. That's one reason. They have they teach you information that it would be hard to get anywhere else. It's another good reason. Of course, I'm making this hypothetical up or this prompt, but those reasons you're now going to draw circles from that reason, and you're going to draw and so what you're doing now is you're actually creating the sentence structure of the first paragraph. So what you're going to do is go back in and just plug in those reasons. Of course, you're going to put them in the sentence format, and you're going to be grammatically correct. But what you're doing now is you're building the structure of your writing. Then you move to the second point. The second point, or the second reason why the History Channel is the best channel on cable TV, is that it's entertaining. How's it entertaining? The History Channel is entertaining because it has a vast variety of different shows. It don't just sit you. It's not boring. You don't just sit in front of a TV and ingest monotonous information all day. They have different shows: American Pickers, Axemen. What's the other show? Swamp People, where they talk about different cultures, ancient aliens. So talk about why. That's why it's entertaining. They have different shows. They're diverse. And once again, in all these shows, they have the people that are at the top of their fields talking about it, or people that are down there in it teaching what they know. So those now become sentences for that second paragraph. Then to plan the third, you go to the third point, and that is that it's fact checked, and of course it's accurate. And you say, hey, because they have the foremost leaders in the sciences that they're talking about, whether it be astronomy, world history, or whatever, they're pretty accurate. So in other words, you talk about what the sources of the information are. The fact that they have good sources of the information are awesome. They have people with doctorates, people that were there, know what happened, and that's why the information is more accurate. And you can even talk if I knew whether or not it was fact checked, I would say that, but I don't. I'm just coming off the top of my head. But we talk about why the information is accurate or is truthful. And those stems, or those that go from that reason out, now become the structure for those sentences, and you can actually stem from those as well. Now it's a little bit harder teaching this because I'm normally used to teaching it on a whiteboard where I can draw out these things, so I'm going to have to get used to it. But I may actually do a class where I may actually film from class, or have a whiteboard. I just have to do the testing and see if you guys can see what I'm writing. But saying all that to say, you gather all this, and as you're planning or writing, rather than walking into your writing having to kind of plan as you write, which can be very hard because sometimes you can start writing and realize, oh, I was wrong. Maybe I shouldn't have done it that way. You have to start back over. It can be very frustrating. So you want to have your points. You want to have your reasons before you even start writing. So when you start writing, you're so well planned, you're just looking at your webbing. It's gonna depending on how complex the issue is, or whatever you're writing. That your planning page may be very, very messy. So you've written out so much stuff and so many reasons why that now it's getting messy. So, but that still is that becomes now the body of your writing, because you're picking these points out, and now you're just taking each line from the web and putting it in the right place. So by the time you do that and you make your points, you've got a body of your paper. So you now have your contention of your thesis paragraph, where you're just saying what it is, what your point of view is. Then you have the three reasons why, and then, like I said before, the bookend, the ending of your paper is the conclusory paragraph. The conclusory paragraph isn't that complex because it's nothing more than almost a restatement of the contention paragraph. So you contend, you tell me why, and then you conclude by telling me what your contention was. But you just start that paragraph differently, and you essentially start that paragraph by saying, "In conclusion," which lets us know you're about to end, just like a preacher. Now, a lot of times preachers will say, "I'm about to take my seat," and they keep going for another hour. But we don't do that in legal writing. In legal writing, when we say "in conclusion," we're wrapping it up. The wrap it up box is the light is on. So at this point, we say "in conclusion." And to conclude my thought process now about the History Channel, I'll say, in conclusion, the History Channel is the best channel on cable TV. It is the best channel on cable TV because it is informative. They give out a lot of information. It is also another reason why it's the best channel on TV is because it is entertaining. They have a plethora of shows and they keep you entertained. Um, and the third and final reason is because they are accurate. The information is accurate and it's fact checked and it's truth and it's true and correct. Um, Therefore, so for the foregoing reasons, the History Channel is the best channel on cable TV. Of course, you better send it structure, but that's it. And so I've just given you guys just in the last few minutes. I just webbed and gave you an answer, a 5 paragraph theme answer for just a simple contention. I'm watching TV, got TV in the background, and that's why I like. And I just told you why I like the History Channel. I just kind of came off the cuff and did that. So that's what legal. That's the first form and the most basic form of persuasive essay writing. Of course, this is the persuasive essay writing I've been taught. Now, legal persuasive essay writing a little bit different. Of course, you have kind of a paragraph structure, and that's what we're going to talk about. Well, not even paragraph structure. Some of it's paragraph, but a lot of it's just how the paper's organized. So there are two main ways that I teach. I know there have been some new ways people have talked about uh, developing different means of legal writing, but the two main things I teach are IRAC and CRAC. I know IRAC, like other country. No, IRAC, not IRAQ, IRAC. That's an acronym, of course. So let's talk about IRAC first. IRAC is issue, rule, analysis, conclusion. So issue is very important, and that's what's so important about in legal writing. Whether you're writing CRAC, which we'll get to, or IRAC, one of the most important things you have to learn to do, and one of the most important skills that you pull out of law school if you ever go. And this isn't law school, but I do want you guys to kind of be able to do this, and that is issue spotting. That essentially means you're trying to figure out what is important, what is the crux of the matter, what am I trying to get, or what is the person asking the question trying to get out of it. And even in real life, of course, I don't always get questions, but what is the issue? What are the important facts that determine or that the case itself hinges on? Like, in other words, what important fact or what is the important question that's going to determine whether in the criminal law case my client is guilty or innocent, or in a criminal procedure case whether my motion to suppress evidence is going to be granted, or whether it's going to be allowed. So that's what we call issue, the issue. So the first thing we want to do, even when we're reading, is figure out what the issue is. Now, that's a skill that can sometimes take a while. And I want to teach you guys how to do it. Of course, it's harder in a class like this. It's online because I can't really, I don't have I have to make sure I get a whiteboard. But it's better when I'm in the class because I can kind of see your eyes and see who gets it and who doesn't, and I can focus. Like this is what issue means. So it's hard for me to gauge right now how much time I need to put into this. So of course, I want you guys to email me and let me know if you have questions, and I can explain it more. And I do have office hours as well. But unless if you can get to me in person, I know this is an online class though. Issue, rule, analysis, conclusion. In certain cases, the issue statement can be kind of general. some law school professors require that the issue statement be more pointed and exact. Like what is the issue as opposed to what the overall overarching answer, question we're asking. Uh, so so let's see, and let's go back to the History Channel. Um, so most issue statements are kind of comparative, but I'll complete it. I'll use kind of the same. And for my History Channel hypothetical or prompt, what I'll say is the issue is whether the issue. I'm sorry. The issue is whether the History Channel is the best channel on cable TV. That is the issue statement. Um, Now I'll say it again. The issue is weather. Now that isn't the weather outside. WEATHER. It is weather, like whether or not. So it is the WHETHER. Weather. The issue is weather. That's how you start off issue based writing. So when you're gonna write an issue based when you're gonna answer the question in an IRAC format, the very first, hopefully the very first. Some people start off with other sentences. I'm not necessarily a fan of that because as a legal, I'm trying to turn you guys into legal writers. That means I have to grade your papers. That means I have to be a legal reader. And being a legal reader, there's certain things I'm looking for, and I'll tell you why these writing formats, whether it be 5 paragraph theme or IRAC or CRAC, they seem kind of boring, and they seem almost like repetitive, like you're repeating yourself. But you're repeating yourself for the reader. You almost have to write as if the reader doesn't know what you're talking about. And even if you're not writing like the reader doesn't know what you're talking about, and the reader doesn't have all day to try to figure out what you're talking about. So it's very frustrating and it's bad writing if the reader can't figure out what you're talking about. So um, you want to open up and get to what the issue is as soon as possible. So I would suggest that you open up and answering the question with an issue statement right there. The issue is whether the History Channel is the best channel on cable TV or not. You can put it or not. So that's the issue statement, and you can even put in some filler sentences talking about what the History Channel is, or maybe 2 or 3 sentences just to give you a paragraph. The issue paragraph isn't usually a very long paragraph because it's kind of straight to the point. It's vastly different from the five paragraph thing where you're kind of giving your thesis and the 3 reasons in one paragraph, and maybe 1 or 2 supporting sentences, and then you're moving on to the first reason. So they're like Iraq and CRAC and 5 paragraph themes writing. They are a lot of they are alike, but they're not alike at the same time. So you'll see some similarities, but they're not the same. Um, so that's the issue. The issue statement where you're telling me what the crux of the matter is, like what the issue is. A lot of times when you know the rule of law and you're applying it, so elements of a certain rule of law, and you're reading through the hypothetical, you know it may look a certain way, but there may be one element that's not quite met, or you can't tell whether or not it's met because there's some type of fact in contention that you need to show that would prove whether or not that element is met. And that is usually where the issue is. So when we talk about pointing issues, we're talking about that. So if the let's go back to criminal law. If the elements of first degree murder are the unlawful killing of another with malice aforethought, with premeditation and deliberation. That's essentially what first degree murder is. So you have a couple elements there: unlawful killing, um, and the unlawful killing, that says a lot, right? So we'll just say unlawful, right? Unlawful is an element in and of itself. That essentially means that you're not justified in killing. So that means that no unlawful killing means that essentially there's no justifier or defense that blocks that killing and allows that killing to be lawful. So you have unlawful killing of another um, with malice and with premeditation and deliberation. So let's say there's 4 elements. We can probably take malice out. So we can say the unlawful killing of another with premeditation and deliberation. So, but I like keeping malice in. Um, So what that means is that must be a unjustified, essentially by saying unlawful, and you partook in some action that led to the death of a person on purpose, essentially, um, and it was done with premeditation and deliberation. That means you planned it. So you did it maliciously. So you did it to do harm, and it was planned. So let's take O.J. Simpson. So of course the allegation that is that he was lying in wait, and of course he was found not innocent or he was acquitted. So it's no longer a point. We're getting tired of people talking about O.J. guilty, and that it doesn't matter anymore. The jury said no, so move on. Um, but back to the point, and trying. Let's say I give you a hypothetical where someone, this won't apply in this class because this is criminal procedure. So, but it's criminal law is more elemental, so it's easier to teach writing with criminal law. But so, let's say we have a fact hypothetical where this guy's mad at his girlfriend. He knows she gets home at 8 o'clock at night every night. So he says, "I want to kill her," and he loads his gun up, and he said, or he packs his his knife, or his machete, and he says, I know she uses this door, so I'm going to sit here and I'm going to be here at 8:15 because that's normally when she gets home. When she goes to the door, I'm going to pop out and I'm going to kill her. And he does it. At that point, it's not in meeting the elements. We're talking about unlawful killings, not justified. Um, Unlawful killing, done with malice. He didn't mean harm. He meant to end her life. Um, and there was premeditation and deliberation. He planned it out. He knew what it was going to be, and he was lying in wait. So those are the elements. So there may be facts like let's say what's a good fact? Let's say sometimes the issue may be um the important issue may be something like, did he kill her? So in most trials, it's about the issue. We know the elements of murder or first degree murder, but a lot of times my client may be saying, "Hey, I didn't do it. Someone else did. I wasn't there." So that means the issue is whether or not he was the person that did the killing. So when we say, the person must have killed, unjustifiably killed another person. So the issue is whether or not they killed the person. So sometimes it depends on what we're trying to prove, or the thing uh, that essentially is a controversy. That's normally the issue. So you open your paper up with the issue is whether. Then, so that's the I in Iraq. Then you have the R. The R is the rule. Now, I just stated a rule in this situation. I stated the rule. By definition, I gave the elements of first degree murder. So, if it's a first degree murder question, what that means is the rule we're going to apply is the rule of first degree murder. So, what I just said first degree murder was by definition, you're going to write that in. The rule of law. So you have a paragraph that starts with the issue is whether, and you couple sentences, you say what the issue is. Then you move on to the next paragraph and you say the rule of law to be applied here is first degree murder. And depending on what jurisdiction you're in, you get the definition. And in North Carolina or whatever state you're in, the definition of murder is blah 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 blah. The first element of murder is this. The second element of murder is this. And you talk about what the rule you're applying. Um, then and so that means you're stating the rule. So that means now you've given the reader your issue, so they know what they're looking for. They know what you're going to be talking about in the first paragraph. Then in the second paragraph, you give them the rule of law to apply. So you explain the dummy. You explain to the dummy what murder is and what it means, and and you can get a lot of meat in that rule paragraph because it's not just giving the elements, but you have to say what the elements mean, the elements of a crime. So by the time you do all that with all those elements of first degree murder, you got you a good little paragraph. You're not having to put fillers in and stretch and do crappy writing just to get that 2 pages you want to get, just so you can make that bare minimum. Now just with you got 2 paragraphs already, you probably got a good chunk, almost a page of writing. So then after the R, which is the rule, or the rule statement, then you do your analysis. The analysis is, remember what I talked about before when I talked about the merger of facts, um, Yeah, the merger of facts where we use facts and we apply them to the law that's given. So you get a fact hypothetical where I tell you someone did, I write in there that someone did this or someone did that. And essentially, I may ask you a blanket question like, what, if anything, can this person be charged with or convicted of in certain situations? And then in that situation, I won't tell you it's murder. I won't tell you this. Sometimes there may be fact hypotheticals where it says, and the defendant is charged with first degree murder in a common law state or wherever it'll say. It'll kind of that gives you pointers on what the rule will probably be because of the jurisdiction. So you kind of know what the rule is, but there's always some type of issue because some element isn't perfectly met, and that usually becomes the issue. But that's when you have to go back to those facts, and you do webbing a lot like you do in Iraq, a lot like you do with 5 paragraph theme. You kind of have your contention or your issue. You don't quite know what the answer is, but you have to go back to that paper. You have your issue, know what your rule is. Now you have to go find specific facts. What facts do you apply to this? What happened in that hypothetical that I wrote out or that you read? What happened in there? What are the facts in there that you can pull out or extract and apply to that rule of law to prove whatever your contention is going to end up being? So, and there's sometimes you might have a question that may mean multiple jurisdictions. So, um, first degree murder may be slightly different from one state to state, from state to state. So let's say if I teach multiple jurisdictions rules on first degree murder, that means, and I don't give you a jurisdiction in the question, that means you might want to tell me about the difference in the jurisdictions, even in, so in doing that, that would be kind of in your rule statement. In this kind of jurisdiction, we apply this. So in this kind of but this is what it means here, and this is what it means there, and this is the overarching, these are the overarching questions we have to ask. So then when you get to your facts, in your facts, when you get to your analysis, you use the facts that you would plug in. So if the issue is whether or not it was premeditated, you had, or are there facts there? And the hypothetical I gave, if this guy knew what time she was going to get off work and he left and he was at her house and hid behind the bushes so he couldn't be seen, that would be lying in wait. Lying in wait is evidence of premeditation, and you can talk about that. So in your analysis, you just plug in the facts where you're almost saying, well, the unlawfulness is met because he wasn't justified in murdering this person or in killing this person. There wasn't a self-defense, or he wasn't justified in taking this person's life. Then two, he took the person's life. So in other words, his actions directly led. Of course, if he stabbed a person and the person died from the stab wounds or whatever, and that means so unjustifiable, causing the death of another. Now, of course, that other is a separate human being, not himself. So we know that you can say that with premeditation and deliberation. So that means you start talking about why it's premeditated and why it was deliberated. And so you talk about the actions or the facts that I gave you, and that's you do all that in the analysis section. And a lot of times the analysis section can be the thickest part of Iraq writing, the thickest paragraph, or sometimes set of paragraphs, because it can be so much writing. You got to break some of that up and have separate paragraphs. So you have your issue, or you state your issue. You tell me the rule of law we're applying. And then you analyze it. You take the facts and you plug the facts in, and you analyze the facts to come up with the last paragraph or last portion, which is called the conclusion. So the conclusion essentially states, it gives your final answer. That's the one thing about law papers. You're going to have to end with an answer. You can't be open-ended. So you got to tell me whether or not this person in the criminal procedure context, whether or not, let's say, this motion to suppress is going to be granted because the officer's conduct was unlawful, or whether the motion to suppress is not going to be granted, is going to be denied because, in actuality, based upon what you gave us in there, in the R, and the A, that that the officer's actions and pulling the person over were actually justified and legal. Therefore, we're going to deny the motion. So I want you to get. So that's essentially where you give me the answer. So even in Iraq writing, where you don't necessarily open up with the answer, you open up with giving us an issue. By the time you get to the end of your writing, I'm gonna need an answer. So you're gonna have to go on one side or the other. You can't ride the fence. So you're gonna have to either say this person is in the murder case, a murder situation, you're gonna have to say they're guilty or not. Or in a procedural situation, you got to say how the court's gonna rule on this motion to suppress. But you have to give an answer. And of course, and you kind of state again why the answer is because it was premeditated and deliberated based upon the actions of what. So so essentially you have I don't want to say four paragraphs because it always ends up being more than just a I paragraph or R paragraph or A paragraph and a C paragraph. I always call it like just portions of the paper. And another thing about this type of writing, whether it be five paragraph theme or IRAC writing, we're not bullet pointing and saying issue dot 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 and then writing under it or issue and then writing under it. You're writing regular paragraphs. I know it's your issue statement because you open up by saying the issue is whether, and then when you break that when you get out of that paragraph and go to a new paragraph, I'm looking again, and if at this point, if you say the rule to be applied and this hypothetical is, that means that means I'm saying as a reader, oh, he's giving me the rule, he's giving me the rationale that he's going to apply, or the law he's going to apply, and coming up with the answer. So I know where you're going. Then after that, you start to analyze. You usually break it up into another paragraph, and sometimes that rule statement can be multiple paragraphs because there may be multiple jurisdictions, or you may have been taught multiple things, multiple jurisdictions, or multiple tests for whatever the body of law is, and you kind of have to tell me about both of them because if I don't tell you what your jurisdiction is, if there are multiple jurisdictions on the hypothetical, that means you may want to let me know about both of them in your writing. So then when you go to the next kind of body of writing, not body, yeah, I guess portion of the writing, that you get to the analysis portion. So when you start explaining what the elements are, and also saying this element is met because hey, he did this or he did that, the officer did this or did that. That means now you're telling me why. Um, you're telling me why you're going to come to the conclusion that you're going to come to. Then when you're done with that, you come to the conclusion. So as a reader, it's almost getting easier and easier as I read down the paper. I start from your issue statement, okay, a good issue statement. Then I go to the rule of law. Then after I go through the rule of law a little bit, I get to the analysis where you start telling me by essentially you're plugging in facts to the hypothetical to let me know, okay, this is what the facts say. So by the facts you give me, I can almost kind of figure out what your answer is going to be. There's nothing wrong. Matter of fact, in legal writing, legal persuasive essay writing, you're supposed to be predictable. The reader wants to be predictable. We want to know exactly what you're about to talk about. So um, you write your conclusory paragraph, and that's where you say, in conclusion, um, defendant is guilty of blah blah blah, and he's guilty of blah 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 because he did in his actions he didn't unlawfully kill someone, and he did it with premeditation and deliberation because he thought about it, planned it, and he lied in wait for the person to get there. So of course you want to plan before you start writing, but I've essentially just given you the breakdown of how that goes. Now this will be a short portion. We'll move to CRAC. CRAC and IRAC a lot alike. They're like brothers. The only difference in between CRAC and IRAC is obvious, right? IRAC starts with the I, CRAC starts with the C. So CRAC is different because in IRAC you open up by giving us the issue, like what we're talking about. So the issue is whether, what question are we answering? What are we trying to figure out? What is the important question we're trying to answer? Um, in conclusory writing or conclusion based writing, or what I call not conclusory, contention based writing, instead of saying an issue, you open up by saying um, what it is. So you can open up by saying this person is guilty of first degree murder. So at the very first sentence of your writing, I see what you're trying to say. So you've opened up, and that's what it is. So at this point, now, I see your contention. You may give a couple more contention, little supportive sentences. But then after that, you're moving on to your next paragraph where you're now talking about um, what the rule is, just like before. You're giving us your rule. Um, then, just like before, you're doing an analysis portion where you're plugging in facts to say why it is what it is. And then you're concluding by giving me, just like in the 5 paragraph theme, the contention or thesis paragraph is almost a direct mirror, the spitting image of the conclusory paragraph. So it's essentially saying it again. So I know it sounds kind of redundant, but that's how we write in persuasive essay writing. But when you're trying to persuade somebody, you kind of have to say stuff over and over again, and give us a basis for why. You always have to explain yourself. It's not just because you said so, because sometimes you can be right, you can be exactly correct, but you can be incorrect because you came to the conclusion based upon the wrong rationale. So you can be right and wrong at the same time in law. I know it sounds funny, but it is what it is. So you have to. It's not just about being correct and being lucky. Sometimes questions are yes or no questions, and you can just get lucky and say, yes, and that answer is right. But in law, we require that you not just give us an answer, but you tell us why. So we always look for the rationale or why you stated it the way you stated, or why you came to that conclusion, and that can determine whether you're actually right or not. Um, that's persuasive essay writing 101. And I'll harp on a little bit more because when we do these essays, you turn them in. I'll grade them and I'll talk about the answers. So I'll do YouTube videos where I talk about the answers. Of the hypotheticals. So we'll do this more. So I'm hoping what I'll do, I won't just post this YouTube video. There are also some other probably way better YouTube videos about legal writing that I will post. So as your professor, I wanted to teach myself. So this is going to be posted, and then I'll probably post some good legal essay writing videos as well. So you can click on this or watch this and then go to something else. But so that this will conclude our legal writing workshop, which is, I guess, part of that first class, the first lecture. So the next lecture, of course, from here on out, we're going through the book. So on July 1st, you should expect we're going to start chapter 1 in that lecture, and we're going to move on to a different chapter on to chapter 2 of the criminal procedure book, and I'll just show you the book that I kind of use. I use the skeletal structure of the book, so you know where I'm teaching from. This is the book. This is the first edition of the book. Now they're up to the third edition, but it's Criminal Procedure by Matthew Littman. Um, Awesome. I like the way his book is organized. Of course, it is a Sage publication book. It's very organized. I like the chapters. I like the way, as a matter of fact, at the beginning of each chapter, it states, it gives a skeletal structure for about what they're going to talk about. So it kind of outlines every chapter. So you go into the chapter and it tells you what the important points are, and then you go to them and they talk about them kind of they more in depth. They even talk about law. So that pretty much wraps it up for today. Another thing I wanted you to take from today is reading the book. Reading, and I know this isn't law school, but I'm teaching the class. So at this point, it's kind of law school just for this class. It's a little bit of law school. So it's important. Your success in my class this semester is going to hinge upon your ability to read and catch what's important. That's why issue spotting in your reading. So that when we say issue, we use the word issue a lot in law. So it's not just the issue statement in your writing, but it's also issues in facts, like trying to figure out what the issue is, what is important here. You can only hone that skill by reading. So you're gonna the book that just doesn't teach you things; it also gives you cases. And so when you're going through the textbook, read those cases because when you're reading cases, you kind of uh, you kind of develop that skill of issue spotting. So it's very important. So just remember that. But we'll talk about that more. You guys have a good day. Take care.